The UK-US Intergovernmental Agreement basically imports a large part of the US FATCA legislation into the UK legislative framework. In FATCA speak, therefore, all UK trusts are entities. The first step to be undertaken by any entity is to determine whether or not it's a financial institution or another form of entity. That's going to depend on the nature of the assets held within the trust and on the nature of the trustees and the fund manager of the trust, if there are any. All trusts need to determine their position under FATCA, regardless of whether or not there are any US settlers or beneficiaries or any US assets within the trust. To help trustees in this process, STEP, in association with the ICAEW and the Law Society, has developed a flowchart and guidance outlining the key questions that must be answered to determine if a trust is a financial institution or not. Broadly, however, the trust itself will be a financial institution where the trustee is a financial institution. The trustee engages a financial institution to manage the trust, or the trustee engages a financial institution to manage the financial assets of the trust. Trusts that are financial institutions may need to register with the IRS and report. Trusts that are not financial institutions are NFFEs in FATCA terms, and they don't need to register or report. They will be reported on by any financial institutions they use. The status of the trust under the IGA does not depend on if there are any US settlers or beneficiaries or any US assets within the trust. We should add 2 points of caution here. The first is that we're shortly expecting revised US FATCA regulations and revised UK guidance. We don't expect those revisions to be fundamental, but clearly it needs to be borne in mind. The other point of caution is the FATCA IGA regulations are extremely complex. Our guidance basically covers the situation for the typical trust as we understand it, but there may well be specific issues and attributes of a trust that raise difficult questions. In those circumstances, specialist advice needs to be taken. I think it's worth saying at this point, though, that the timeline here, the deadline, is getting quite pressing. The IRS web portal is already open for financial institutions to register. You will be very shortly contacted by many of the financial institutions you have contact with trying to establish your status under FATCA. They will want to know if the trust is a financial institution, and if it's a financial institution, what its registration number is. All the questions we're going to pose over the following few minutes have to be answered by October this year at the latest. That is the deadline for all institutions to register if they need to do so. The UK-US IGA only covers institutions and entities that are UK tax resident. If a trust is tax resident elsewhere, clearly it may fall under a different IGA between a jurisdiction and the US, but only UK tax resident trusts are subject to the UK-US IGA. The other significant exception relates to registered charities. They are treated as deemed compliant financial institutions and do not have to register with the US authorities. The status of the trust under the IGA depends on the nature of the trust's assets, the trustees, and the fund managers if there are any. It does not depend on if there are any known US connections within the trust or if the trust holds any US assets. Essentially, therefore, there are a series of tests designed to establish the status of the trustees, the fund managers, and the trust in terms of its assets. The first of these tests is the question, does the trust act for customers, and is 50% or more of the trust's gross income attributable to a range of financial assets or portfolio management or fund administration? In reality, we expect most family trusts to answer no to this question for the simple reason that most family trusts will not act for customers. We can therefore probably pass quickly on to the next key test, which is the trust managed by an entity that acts for customers and where more than 50% of gross income is attributable to a business trading in a range of financial assets or portfolio management or fund administration. This is actually going to be the key test for most trustees to answer. There is no definition of managed in the UK regulations, and we're trying to get clarification on this point from HMRC. We can, however, look to the US regulations for some assistance in this issue. And within the US regulations, it's clear that managed is to be interpreted very widely. It will cover both trustees of the trust and discretionary fund managers of the trust. Therefore, if the trustees appoint a discretionary fund manager to manage the trust assets, the fund manager is likely to be a financial institution, and this will make the trust a financial institution for FATCA purposes. In addition, our current understanding is that if the trustee is a corporate trustee, the trustee is likely to be a financial institution, and this will also make the trust a financial institution for FATCA purposes. It may be worth mentioning at this point that if a trust simply has a bank account with a bank, that doesn't create a danger of the trust becoming a financial institution. In those circumstances, the bank is not deemed to be managing the trust assets. If the answer to the last question about the nature of the trust managers was no, there are a couple of final tests that you need to apply before you can be certain whether a trust is a financial institution or non-financial foreign entity. The first of those tests is more than 50% of the trust's income attributable to investing, reinvesting, or trading in financial assets? This is a rather broader test than the previous test we applied to the trust assets. It's also notable that this test doesn't mention anything about the trust having to act for customers. If, however, the answer is no to this question, then we can definitively say the trust is not a financial institution for FATCA purposes. It's a non-financial foreign entity. Non-financial foreign entities do not need to register or report. If they have an account with a financial institution, they will need to confirm their status as an NFFE to the institution. And if they have an account with a financial institution, they will need to do due diligence to see if there are any specified US persons connected to the trust. They will be then reported on by the financial institution. If the answer to the financial assets test is yes, the trust does get more than 50% of its income from financial assets. There is one final test that must be applied, which again goes back to the nature of the trust managers. And that is simply, is the trust managed by a financial institution? Again, the definition of managed is a broad one and looks at both the trustees and the asset managers, if there are any. If the answer to this question is, however, yes, then the trust is a financial institution. If the answer is no, then the trust is an NFFE. If a trust has a reporting financial institution as a trustee, and this would typically be where it has a corporate trustee, the trust will become a non-reporting UK financial institution and become a trustee documented trust. The trust itself does not need to register or report. Instead, the trustee will register and report on behalf of the trust. It's worth saying many practitioners have suggested that this is, in practical terms, probably the easiest way forward for many trusts. It will ensure relatively straightforward compliance for both the trust and the trustee in these circumstances. The next option is that the trust registers as a financial institution with the IRS. It must obtain a Global Intermediary Identification Number, a so-called GIN, and it will then need to report as a financial institution via the HMRC each year to the IRS. It will also need to declare its status as a reporting financial institution to all financial institutions it has accounts with, and it will need to provide them with its GIN. It can use third-party service providers to do an awful lot of its compliance functions, but the compliance responsibilities always remain with the trust. Another option is to become a sponsored investment entity. The intention in developing this option was that trusts that had a discretionary fund manager could opt to be sponsored by that discretionary fund manager, and he would take care of FATCA due diligence and reporting. The sponsor therefore must be authorised to manage the trust, and the sponsor must register with the IRS as a sponsoring entity. The sponsor must register the funds it sponsors as sponsored entities with the IRS, and the trust will remain liable for any compliance failure of its sponsoring entity. However, the trust will remain liable for any compliance failure of its sponsoring entity. It's also worth noting that anecdotally, we hear that many fund managers are actually very reluctant to become sponsors for trusts, and those that are often asking substantial fees for their services in this area. A further variation on the sponsored theme is for the trust to become a sponsored, closely held investment vehicle. This is very similar to the sponsored investment entity category, but the sponsor does not have to register the trust, just report on them. It's a classification only available, however, to trusts that don't hold themselves out to unrelated parties as an investment vehicle, and where the trust has 20 or fewer individuals that own what are called equity or debt interests. This may exclude some trusts. Again, however, the key challenge in practice may be to find a financial institution prepared to act as a sponsor for a closely held investment vehicle. The final option available to trusts that are financial institutions is that they opt to become owner-documented financial institutions. They must appoint a designated withholding agent. An owner-documented status only applies to payments from and accounts with the designated withholding agent. The designated withholding agent must be a reporting financial institution, and it needs to undertake all due diligence and reporting for the trust. The trust itself need not register with the IRS, but again there is a practical difficulty of finding someone prepared to be a withholding agent in these circumstances. As I noted at the beginning, we are expecting revised US regulations and UK guidance very shortly. There's also inevitably ongoing speculation that FATCA could be delayed yet again. I think, though, trustees are well advised not to put any strong bets on further delays in the FATCA process. The IRS portal is now open for financial institutions to register. That's where you will get your registration number as a financial institution. Financial institutions need to register by the 25th of April to be on the first list of financial institutions, which the US will publish on the 2nd of June 2014. The regulations insist that financial institutions must be on the list that will be published by the US on the 1st of January 2015. And to meet the deadline for that, they will need actually to register on the IRS portal by the 25th of October 2014. It's worth saying, though, that before those deadlines, we expect many financial institutions to start inquiring of trustees what the status of the trust is under FATCA. The UK IGA with the US is technically a Model 1A type IGA, and this has formed the basis for most of the other IGAs that have been negotiated around the world. It's certainly the base for the IGA that the UK has negotiated with the Crown dependencies and the overseas territories, and whilst some of the details of those IGAs are still being worked out, the basic framework ought to be pretty similar. We also have the OECD developing an IGA type model for automatic exchange of information for tax purposes, which is expected to go live in early 2016. And that again is going to be based very heavily on the Model 1A type IGA that the UK has negotiated with the US.